Yes, please.
For hearing item 1.
Made clear, Your Lordship.
Yes.
Here, the appellant was convicted for life sentence under section 302. Here, the wife of the appellant died in the house, in his house, in burn condition, and thereafter, the trial court relied on the evidence of on the dying declaration produced by the prosecution side, which was recorded under section 161. Only on that basis, the petitioner is convicted. Now, only the thing is that whether this dying declaration can be relied on or not. This is the question before Your Lordship now. Page 4 is the FIR.
Yes.
Before coming to the contents of the Lordship, may I kindly note down on page 1, Your Lordship will kindly see page 1 of the paper book, column number 3, small b. Information received time 9. It is received by the PS on 9 at 9 p.m. But the outpost received the information at 4 p.m. And date of occurrence is 19/12/2016. FIR was lodged on 24/12/2016. Till this period, Lordship, there was no dying declaration, nor any whisper about torture or assault on the victim. Only after lodging of the present case, this dying declaration came into existence, Lordship. Page 4 is the FIR. May I read, Lordship?
Yes.
Sir, I have the honor to state that about 3 months ago, below mentioned accused number 1 got married to my elder sister, Momota Khatun. Since after her marriage, the accused person had been torturing my elder sister physically and mentally, demanding properties. Meanwhile, around 2 a.m. on 19/12/2016, said accused person called accused number 2 to his house, and they together poured kerosene on the person of my elder sister and set her on fire with an intention of killing her. Presently, my elder sister is undergoing treatment in critical condition in Lower Assam Hospital. It is to be mentioned here that the lodging of this Azahar got delayed as I was busy with her treatment. Here, Lordship will kindly see the accused number 1 is before Your Lordship as appellant, and accused number 2 against him FR submitted. Even he was not arrested on the basis of the dying declaration. And another aspect Your Lordship will kindly note that FIR says, presently my elder sister is undergoing treatment in critical condition. On the same day, after half an hour, the dying declaration was recorded without any certificate or endorsement from the concerned doctor whether she is fit to give the dying declaration or not. And another aspect, Your Lordship will say that it is mentioned here that lodging of the Azahar got delayed as I was busy with her treatment. He was constantly with the victim, but prior to lodging of this Azahar, there is no mention that victim has informed such and such incident. This is also not there. So everything comes after this Azahar has been lodged. Now, PW1 is the informant, page 10, and informant is the brother of the deceased.
Yes.
This is Momota.
Name is Guddu Ali.
Yes, Lordship.
He's the informant.
He is the informant. Younger brother of the deceased.
Yes.
Deceased Momota Khatun was my elder sister. Momota got married to accused Hafizur Rahman. After 4 months of the marriage, the accused demanded an amount of rupees 1,50,000 as dowry from our family. As we are poor, we could not give the money. The accused used to assault my elder sister as we could not give him money. The incident took place in 2016. Around 2 a.m., the accused assaulted my elder sister. Then my elder sister poured kerosene on her person and was sitting there. She thought that the accused would pacify her, but instead of pacifying her, the accused said, "Die if you want to die, intend to die," and burn a matchstick and set my elder sister on fire. When the neighbors of the accused informed us, we went there and took my elder sister to civil hospital. As she was not kept in civil hospital, we took my elder sister to Lower Assam Hospital. Here just I'm pausing for a moment. Your Lordship has seen that he is saying that he took the victim to hospital, but this is not correct. As per FIR as well as from the other evidence, your Lordship will find that accused doused the fire and he took the victim to the hospital. He was present all along with the victim, and subsequently he was taken to the police station. He was handed over the police, and thereafter the present affair was lodged. As I was busy with her treatment there, I lost the Azahar after 5 days. My elder sister made her statement before police while she had some consciousness. Police recorded her statement in a video, but that video is not exhibited till now, Lordship. We handed over the accused to police. Exhibit 1 is the Azahar I lost, and Exhibit 1.1 is my signature. Police seized a Kabinnama and an agreement for marriage executed before notary through Exhibit 2, seizure list. Exhibit 2.1 is my signature in the seizure list. After seizing the documents, police kept the same under my Jimma. Material Exhibit 1 is the Kabinnama and Material Exhibit 2 is the marriage agreement containing 5 pages. Exhibit 3 is the inquest report and Exhibit 3.1 is my signature. Deceased was my only sibling, Cross. The original house of the accused is at Satipur. I did not go to the original house of the accused. My elder sister got married to the accused on her own will following a love affair. Because of this reason, Lordship, the Kabinnama and this agreement was exhibited. My elder sister and the accused had been residing in a rented house. They resided in rented house subsequent to the marriage. The accused worked as a contractor at BRPL. The accused and the deceased used to live in the rented house where my sister died only 2 weeks before the incident. I do not know if they resided in the house of the accused at Satipur prior to that. My elder sister had no children. No demand was made at the time of marriage. It was not mentioned in the Azahar that the accused demanded an amount of rupees 1,50,000 after 4 months of the marriage. I saw both of them leading the conjugal life happy and peacefully. This is also supported by all other witnesses. The house where the incident took place is less than 1 kilometer away from my house. My elder sister came to our house, but the accused did not. Letter says when the accused went to his workplace, my elder sister used to come to our house sometimes, and the accused took her back to his house when he came back from workplace. Police questioned me on the day I lost the Azahar. It is not a fact that I did not state to police in such terms. Around 2 a.m., the accused assaulted my elder sister. Then my elder sister poured kerosene on her person. She thought that the accused would pacify her, but instead of pacifying her, the accused said, "Die if you intend to die," and burn a matchstick and set my elder sister on fire. It is not a fact that I did not state to police in such terms. When the neighbors of the accused informed us, we went there and took my elder sister to civil hospital. My elder sister made statement to police when she had some consciousness. Police recorded her statement in a video. I do not know when the fire caught her, but having received the information at 2 a.m., I went there. Even in cross this about he was asked about video because there was no video in existence on that day. Therefore, the defense took the chance to ask him that risky question that whether any video was there or not. By calling a 108 ambulance, the accused took my elder sister to civil hospital. Later on, I took my elder sister to Lower Assam Hospital. The accused accompanied us. He purchased medicines for 2 or 3 days. It is not a fact that accused paid the entire bills of the hospital. I never visited the rented house of the accused. My elder sister told me that they stayed in a single rented room. It is not a fact that the accused was not available in the house at the time when the fire caught her. It is not a fact that kerosene got leaked from the stove, sprayed to her chador, and then fire sprayed to her from the stove. It is not a fact that the accused did not set her on fire. It is not a fact that the statement that the accused had been demanding money from my elder sister since 4 months after marriage is false. It is not a fact that I have adduced false evidence and that I lost the case on false ground. Now, PW2, mother of the deceased, page 14. What you will find.
Yes.
My daughter's name is Monwara alias Momota Begum. We married her off to accused Hafizur Rahman. The accused assaulted my daughter and demanded an amount of rupees 1,50,000. As I could not give him money, he used to assault and torture my daughter. In a night about 5-6 months ago, a boy from the neighborhood of the accused came and informed us that my daughter got burned. Then we went to the house of the accused. My daughter was first taken to civil hospital and then to Lower Assam Hospital. When police questioned my daughter in my presence, she stated that the accused had assaulted her since the evening with regard to money, and then being unable to bear the torture, she had poured kerosene on her person at midnight and she was crying. Here, Lordship will kindly note that she herself is saying she was present when statement was recorded. In this regard, Lordship, my submission would be that when dying declaration is recorded and the relatives are present, that itself casts doubt. In this regard, I will submit one judgment of Honorable Apex Court also. She further stated that she thought that the accused would pacify her, but instead of pacifying her, he told, "You have not died yet, still waiting." He had burned a matchstick and set her on fire. My daughter died after a week while undergoing treatment in Lower Assam Hospital. My son lodged Azahar with the PS while my daughter was undergoing treatment in Lower Assam Hospital, and police recorded my statement before the death of my daughter. Now cross. It is not a fact that I did not state to police in such terms. When police questioned my daughter in my presence, she stated that the accused had assaulted her since the evening with regard to money, and then, being unable to bear the torture, she had poured kerosene on her person at midnight and was crying. She further stated that she thought that the accused would pacify her, but instead of pacifying her, he told, "You have not died yet, still waiting." He had burned a matchstick and set her on fire. My daughter had a love affair with the accused for 2 years. Dowry was not demanded in the marriage. We did not give dowry in the marriage. The accused worked as a contractor in BRPL. The original house of the accused is at Satipur. The accused kept my daughter in rented house at Bhoalaguri. During that time, they were in visiting terms with us, and the relation between us was cordial. When the accused went to his workplace, my daughter used to come to my house, and while coming back from his workplace, The accused used to bring her back to his house. They had a single rented room. I do not know the date and day of making demand of money. We neither provided treatment to our daughter when she was assaulted nor lodged any case against him. Having received the information, I went to see my daughter at hospital on the following day. It is not a fact that accused paid all the expenses of the hospital. The accused used to cook on stove. It is not a fact that while cooking on stove, kerosene leaked from the stove and spread to the cloth of my daughter, and thus fire spread to her from the stove. It is not a fact that it is false that the accused assaulted my daughter in demand of money. It is not a fact that my daughter did not make any statement to police. It is not a fact that since my son lodged the Azahar, I have adduced false evidence. Now, PW3. PW3 is niece of deceased. Oh, sorry, deceased was niece of PW3. Oh.
Yes.
Deceased Momota was my niece. She got married to accused Hafizur Rahman. Having heard that Momota got burned, I first went to the rented house of the accused. Thereafter, I went to civil hospital and Lower Assam hospital also. When police recorded the statement of Momota at Lower Assam hospital, I was present there. So PW3 being relative, she was also present there. Momota stated to police that the accused demanded an amount of rupees 1.5 lakh from Momota after the marriage. Hafizur tortured Momota as he could not give money. Momota further stated that after consuming liquor as the accused assaulted her, she poured kerosene on her person. She further stated that she thought that accused would save her, but after coming back about an hour later, the accused said that you have not died yet and set fire on her by lighting a matchstick. The accused went to the hospital only for 2 days. He did not come to hospital thereafter. He also did not bear the expenses of hospital. Later, Momota died in the hospital. Cross. We were not in visiting terms with the accused. The accused and Momota came to the rented house there 3 months prior to the incident. Prior to that, they resided at the house of accused at Satipur. There had been a love affair between the accused and the deceased. The accused did not raise any demand at the time of marriage. They had only a single rented room. They had only a single rented. This is important because Lordship, another person, CW1, was also present in the said room, Lordship, when the incident occurred. They had a single rented room. Around 10:11 a.m., after 3 days of the incident, police took the statement. I have forgotten the exact day of taking the statement. Police took the statement of Momota while she was in Lower Assam hospital. It is not a fact that Momota did not make any statement to police. It is not a fact that at that time, Momota was unable to speak. The husband of my another niece called a 108 ambulance and took Momota to hospital. The accused also accompanied them. It is not a fact that the accused paid all the expenses of hospital. The date of occurrence was 19th day of the month. I cannot say the month and year. It is not a fact that the accused did not set fire to Momota. It is not a fact that Momota caught fire from the stove while she was cooking food in the stove, and as a result of which she died. It is not a fact that I have adduced false evidence as deceased was my niece. Now, PW4, grandmother of deceased. Grandmother is 40.
Yes.
PW4 is the grandmother of deceased, but probably her age is wrongly reflected as 40 years. Because she herself stated that the deceased was her granddaughter. Deceased Momota was my granddaughter. Momota got married to accused Hafizur. Since after the marriage, Hafizur tortured and assaulted Momota. The accused demanded an amount of rupees 1,50,000 from Momota's father. But as they could not give the money, the accused used to assault Momota. The parents of Momota could not give the money for their poverty. Being unable to endure the atrocities, one day Momota poured kerosene on her person and was sitting, supposing that her husband would come and save her. But her husband said, "You have not died yet, die now," and set her on fire by lighting a matchstick, and consequently, the entire person of Momota got burned. Then Momota was taken to Lower Assam Hospital, and the accused took an amount of rupees 20,000 from me to meet the expenses of hospital. Momota stated about the incident to police prior to her death, and I was present there. Later, Momota died at hospital, but the accused did not visit to know about her condition. Here, regarding taking that money, I will submit for lordships that at that time, due to demonetization, there was some scarcity about currency notes, which has come in the evidence also. Lord. Cross. Hafizur stayed in a rented house. The house of the accused is about 1 kilometer away from mine. They got married to each other following a love affair. I do not know when they got married. I do not know where the house of Hafizur's father is situated. Subsequent to the marriage, they both stayed in a rented house. Letter says they stayed on rented house 1 or 2 weeks before her death. Prior to that, Hafizur and deceased used to reside in the house of Hafizur. I was not in visiting terms to the accused to the house of Hafizur. I do not know where Hafizur used to work. Hafizur and Momota were not in visiting terms with the father-in-law of Hafizur. I did not go to hospital the night on which fire caught Momota. I went to hospital on the following day. I went to the hospital one day only. I cannot say the day and date of catching fire and death of Momota. I cannot say on which date the demand of rupees 1,50,000 was made. I do not know when the Azahar was lost. It is not a fact that I did not state to police that the parents of Momota could not give money for their poverty, and that the amount of rupees 20,000 taken from me for the treatment of Momota while she was in Lower Assam Hospital could not be repaid to me. Entire body parts of Momota, including face, got burned, and the burned portion were bandaged. Momota was unable to eat and speak. So now here comes Momota was unable to eat and speak. It is not a fact that the statements that Momota stated about the incident to police and that I was present there are false. Hafizur and Momota stayed in a single rented room, and they had cooking, dining, and bedding arrangement in that room itself. I do not know if Momota used to cook on stove. It is not a fact that while she was preparing food on stove, fire spread to Momota from it. It is not a fact that statements that the accused demanded an amount of rupees 1,50,000 and that he used to assault and torture Momota are false. I heard that the accused called 108 ambulance and took Momota to hospital at night itself. It is not a fact that accused did not set Momota on fire. It is not a fact that fire spread from the stove accidentally to Momota and caught her. Now, PW5 is the landlord where this deceased and appellant were residing. PW5.
Yes.
Accused Hafizur Rahman and deceased Momota Khatun stayed in my house as tenants only for 7 days. On the day of occurrence, having heard a hue and cry after 1 a.m. while I was sleeping, I along with my other tenants came forward and saw Momota on flames and her husband Hafizur Rahman trying to extinguish the fire by covering her with a blanket. When I asked who set Momota on fire, she did not reply. Then I asked Momota's younger sister Malati and Malati's husband Kasem Ali, who had been residing as my tenant in another room within the same compound, to call a 108 ambulance. When the vehicle arrived, I sent Momota to hospital. Momota and accused used to stay in my house only at night during the period of their tenancy for 7 days. They did not stay in my house during their day hours. During their stay in my house, no assault took place between them. So prior to that, there was no assault or other things. In cross, the accused and Momota took a single room on rent. They had their all arrangements, including cooking and sleeping in that single room. I did not see any difference between the couple during their stay in my house. The accused too accompanied while taking Momota to hospital. I have forgotten where Momota was taken first, but I found Momota undergoing treatment in Lower Assam Hospital after 2 days. When I went to Lower Assam Hospital to see the injured, I found the accused there. Now PW6. PW6 is neighbor. Accused Hafizur Rahman and his wife Momota resided in my house on rent for 1 week only. On the day of incident at 1 midnight, I heard alarm of Momota. Then I came out and had gone to the house of Momota. Then I had seen Momota in burned condition. Momota was screaming to save her. Her husband, that is accused Hafizur Rahman, covered her with a blanket and hold her. On being asked by me, Momota only told to save her, while accused said nothing. Prior to the incident, I did not hear any halla or quarrel in the house of the accused. Then Kasem Ali took Momota to hospital. Cross. Accused took only 1 room on rent, and the same room was used for cooking also. They usually go outside in the morning to do work and in the evening return. They cooked food in stove. On the day also, the accused and the deceased went outside in the morning to do work, and in the evening, after returning to the room, took meal. And at night, the incident occurred. It is not a fact that before police, I did not state that Momota screamed to save her. PW7, brother-in-law of deceased. Accused Hafizur Rahman married an elder sister of my wife, namely Momota. At the time of incident till date, I reside in the house of Zainuddin on rent within the same premises where accused resided. On the day at 1 midnight, hearing halla, I came out and had seen Momota in burned condition while accused Hafizur tried to put out the fire by covering a blanket. My wife caught hold Momota and I called 108 ambulance. At first, Momota was taken to Bongaigaon Civil Hospital, but as the injured was not admitted there, then she was taken to Lower Assam Hospital. After 6 days, Momota expired in hospital. On the day of incident at about 9:30 p.m., Momota, Hafizur and Hibzur's friend Sofiur was watching TV in my house. So Sofiur is CW1. During watching TV, as it was late, hence Momota asked the accused to leave my house as for watching TV later. It may cause disturbance to my children. Then accused replied that he is going and asked her to proceed. And in that, accused pushed Momota by hand, due to which Momota's head hit the wall of my house and sustained injuries. Momota in hospital told me that she set fire herself. At this stage, witness is declared hostile. Crossed by prosecution. It is not a fact that before police I stated that I heard that the accused had quarreled with the deceased, and in the night of quarrel, Momota poured kerosene over herself, and husband Hafizur Rahman told her that if you go so eager to die, then you better die. And after telling that accused light a matchstick and put on her body, she died for that only. It is not a fact that before police I stated that for having liquor in my house by accused Hafizur Momota, by having liquor in my house by accused Hafizur, Momota threw away the liquor and then accused Hafizur slapped her, as a result of which she hit on wall and sustained injury on her head. It is not a fact that I have good relation with the accused and have deposed falsely in favor of the accused. Crossed by defense. The relation between the accused and deceased was good. Accused and deceased took only one room on rent, which was used for cooking also. Accused used a stove for cooking. Accused and the deceased left my house at about 11 p.m. Thereafter, meal was prepared by Momota and they took meal. Accused put out the fire. Accused and my wife accompanied the NGO to hospital, and the accused was all along with his wife in hospital. I do not know if the deceased ablaze from fire of stove while cooking. It is not a fact that the accused pushed the deceased, while police wrote in my statement that was not stated by me. PW8. He is doctor. He issued one certificate that that patient died, and the police informing police that postmortem is required to be done. And victim died on from his evidence. It appears 26/12/2016 at 1:30 p.m.
PW8 issued death certificate.
Inform the police that the patient had died and she needs to be postmortem. Postmortem examination is required to be done on her body. And prior to that, there is no record of any GD&T or nothing is that sort of.
Yes.
Now PW9. PW9 is a member of an organization, not related. The incident took place some months back. Momota and Monuara was my fellow villagers. I heard that quarrel took place between Momota and her husband. Identifies the accused by pointing to him in the dock. And then Hafizur set Momota on fire. Having heard that Momota was taken to hospital, I went to hospital. I went to hospital to see Momota on several days. Momota died in the hospital after 6 days of the incident. After the death of Momota, magistrate came to hospital and held inquest on the dead body of Momota. Exhibit 3 is the inquest report and Exhibit 3(2) is my signature. Police seized a kabinnama and a marriage agreement in my presence. Exhibit 2 is the seizure list and my signature. I heard that accused assaulted Momota on the day of occurrence. Momota poured kerosene on her person out of anger and was sitting there. And then the accused said, "You have not died yet," and set her on fire by lighting a matchstick. The Lordship will kindly note that the event, the person who is not related to the deceased or accused, he is also deposing in same line like other relatives.
No, but who has seen the accused lighting fire on
No one has seen.
victim?
No
How
one.
could they know? They were not present there.
They were not present there.
So from where? have
Only
they
CW1 was present there. Only CW1 was present there who was staying in the same room. He said after hearing the scream, he woke up and he saw that accused was dousing the fire on the body from the body of the deceased. Prior to that, there was no quarrel or nothing that sort of.
So is it that this part of the evidence is all hearsay?
All here.
That the accused set the victim on fire?
On the
Because no
basis
one
of
was
the-
present there. So on what basis are they saying this?
On the basis of the dying declaration she made before the police, because they were all present, most of the family members were there.
Acha, the victim has told police, according to the prosecution, that it is the accused who has set her in fire.
Yes.
Acha, we'll come to that. Yes, please proceed.
Cross-examination. I did not see the incident. The rented house of the accused and the deceased is about 1.5 kilometers away from mine. It is not a fact that I did not state to police in such terms. I heard that the accused assaulted Momota alias Monuara on the day of occurrence. Momota poured kerosene on her person out of anger and was sitting there. And that then the accused said, "You have not died yet," and set her on fire by lighting a matchstick. It is not a fact that the statement that the accused set Momota on fire is false. I do not know if the deceased and the accused used to cook their food on stove. It is not a fact that fire spread from the stove and caught her. The face, neck, and back of Momota got burned. I have not seen the seized material in the court today.
Who is PW9? Who is he?
He is member of AMSU, Lordship, organization, one member of one organization.
Yes.
Now, PW 10. Doctor who conducted postmortem examination, Lordship. Here in the postmortem examination, it is not mentioned the percentage of burn. An opinion, your Lordship will find page 35, last paragraph. In my opinion, the cause of death is due to septicemia following burn injuries, which is antemortem in nature. Approximate time since death was 24 to 30 hours. Exhibit 5 is the postmortem examination report, wherein Exhibit 5 is my signature.
Yes.
Page 36, PW 11. He prepared inquest report on 27/12/2016 at 9:27 AM. And victim died on 26/12/2016 at 1:30 PM. The following day.
Yes.
So that is not relevant here. So I'm skipping his evidence, Lordship. Page 38, PW 12. She is cousin sister of deceased, declared hostile, who were residing with the deceased and appellant in the same compound. I know complainant Guddu Ali. Accused Hafizur Rahman is my brother-in-law, sister's husband. My cousin, my mother's younger sister's daughter. Momota got married to the accused. Momota died about 1.5 years ago. She died of burning around 9:30 PM on the day of occurrence. Hafizur and his friend Sofiur visited my house and left after having food. Both of them left my house. Later on, at about 1 AM, when Sofiur called us, I, along with my husband, came. We saw many people outside. The house of the accused is near my house. We went there and saw Momota caught fire. As Momota told to take her to hospital, my husband called an ambulance. and we took her to civil hospital. Later on, when Mamata's mother came, I left the hospital. Later, Mamata died at Lower Assam Hospital. I asked Mamata several times how the fire caught her, but she did not tell me anything. She only asked me to take her to the hospital. I know nothing more than this. At this stage, witness is declared hostile. Crossed by prosecution. It is not a fact that I stated to police in such terms. So far, I heard on 19/12/2016, the couple quarreled with each other at night. Then Mamata poured kerosene on her person. She kept standing for a while, for a long time, supposing that the accused would come forward to save her. As her husband did not come close to her, she herself went near her husband. Then her husband said, you intend to die now, and set her on fire by lighting a matchstick, and consequently, she died at Lower Assam Hospital. It is not a fact that since her husband resided near me, I have adduced false evidence. Crossed by defense. Accused used to reside in a rented house near my house. His original house is Dhaligaon. Going to the house of the accused at night, I found that accused holding Mamata by wrapping a blanket around her. The accused asked my husband to call a 108 ambulance. The accused accompanied us and Mamata to the hospital. The accused and Mamata took a room on rent and they used to cook their food in that room itself. They used to cook on stove. Now, PW 12, PW 13, he is the IO of the case.
Yes.
On 24/12/2016, I was posted as ASI at North Bongaigaon PP. On that day, one Gudu Ali lodged an FIR at North Bongaigaon PP alleging that on 19/12/2016 at 2 a.m. at night, the accused Hafizur Rahman and Sofiur Ali poured kerosene on her body, on the body of her sister Mamata Khatun, and set fire, and that the injured was taken to Lower Assam Hospital, Bongaigaon. The complainant Gudu Ali produced the accused Hafizur Rahman along with the FIR. So here your lordship will find that prior to lodging of the FIR, complainant took the accused to the police station and then submitted the FIR. The complainant Gudu Ali produced the accused Hafizur Rahman along with the FIR. On receipt of the FIR, the ICSI Devojit Sharma made the GD entry number 614 dated 24/12/2016 and sent the FIR to the OC Bongaigaon PS for registering a case and endorsed me to investigate the case. Exhibit 6 is the extract copy of GD entry number 614 dated 24/12/2016. And Exhibit 61 is the signature of Devojit Sharma, which I know. Finding the informant at the PP, I recorded his statement. Then I went to Lower Assam Hospital. In presence of the relatives to the injured, namely Khatun Bibi, Asiron Bibi, and Kamala Begum, recorded the statement of the injured and also recorded the statement of Khatun Bibi, Asiron Bibi, and Kamala Begum in the hospital. I visited the place of occurrence and prepared the sketch map of the PO. Exhibit 7 is the sketch map and Exhibit 7.1 is my signature. I also recorded the statement of Joinuddin Sheikh and his wife Delijan Bibi, in whose house the accused and his wife resided on rent. The OC Bongaigaon PS registering a case being Bongaigaon PS case number 82216 under section 198A 307 IPC entrusted me to investigate the case. On 24/12/2016, I interrogated the accused Hafizur Rahman, arrested him, and on 25/12/2016 forwarded him to the court. On 27/12/2016, the doctor of Lower Assam Hospital informed me that injured Mamata expired on 26/12/2016. I took steps for conducting inquest on the dead body by magistrate. Thereafter, I recorded the statement of Dr. D. Hazarika, Gudu Ali, Komela Begum, and Anarul Hussain, and sent the dead body to Bongaigaon Civil Hospital for postmortem examination. Another FIR named accused Sofiur Rahman himself came to the PP. Accordingly, I interrogated him and finding no material, released him. On 28/12/2016, I visited the house of the informant and seized the Kabinnama and then one notary certificate on being produced by the informant. Exhibit 2 is the seizure list and Exhibit 2-3 is my signature. I also recorded the statement of witnesses of seizure list. On death of injured, I prayed before the learned CGM Bongaigaon to add section 302 IPC, which was accordingly allowed. Thereafter, as directed by OC, I handed over the case diary to OC Bongaigaon PS. PW7 Kasem Ali stated before me that I heard that accused had quarrel with the deceased, and in the midst of quarrel, Momota poured kerosene oil over her body, and her husband Hafizur told her that if you so eager to die, then you'd better die. And after telling that, accused light a matchstick and put on her body, and as a result of which she died. PW12 Rohima Begum stated before me that she heard that on the night of 19/12/2016, both husband and wife entered into a quarrel, and then Momota herself poured kerosene oil over her body and was waiting for her husband with a hope to save her. While her husband did not come near her, she herself proceeded towards him. Then her husband saying that if you eager to die, then die, set her fire by a matchstick, resulting which she died in Lower Assam Hospital. Cross. As per the FIR, the date of occurrence is 19/12/2016 at 2 a.m. An FIR was lodged on 24/12/2016, North Bongaigaon at 4 kilometers away from the place of occurrence. I recorded the statement of the injured on 24/12/2016 at Lower Assam Hospital, but I did not obtain her signature in the statement. I also did not obtain the signature of Khatun Bibi, Bosiran Bibi, and Komela Begum, in whose presence the statement was recorded. The injured was in burn unit of the hospital. Before recording the statement of the injured, I did not obtain medical certificate from doctor as to whether she was mentally fit to give statement. In the statement of the injured, I also did not mention that as per her wish and her version, I recorded the statement. So it is voluntary or not, that is not ascertained by the IO. I seized no any burned materials. The house of the informant is at Chinese Market, Bongaigaon, and at the place of occurrence is at Bhaulaguri. I have not collected any medical document of the injured from Bongaigaon Civil Hospital as well as Lower Assam Hospital, where the injured was taken after the incident and was provided treatment. It is not a fact that injured was not in a position to speak, and she did not give any statement before me. I did not take steps to record the statement of the injured by doctor. In the FIR, it is not mentioned who wrote the same. PW1 Gudu Ali had not stated before me that on night at 2 a.m. accused had beaten my elder sister. Then her sister poured kerosene oil upon her, thinking that accused will save her, but the accused did not do so, and saying that if you wish to die, then let you die, put a matchstick upon her body. PW1 Gudu Ali had not stated before me that on receiving the information from neighbors of the accused, we took my elder sister to Bongaigaon Civil Hospital, and as my elder sister was in sense to some extent, she gave her statement before investigating officer, which was recorded by video. PW4 Bosiran Bibi had not stated before me that for poor economic condition of parents of Momota, they could not pay the demanded money, and the accused Hafizur could not repay 20,000, which amount was he took from her during treatment of Momota at Lower Assam Hospital. PW9 Anwarul Hussain had not stated before me that I heard that on the day of incident, accused had beaten Momota alias Monwara. Then being angry when Momota poured kerosene oil upon her body, was sitting, then accused saying that do you still not die? Set her fire with a matchstick. It is not a fact that PW7 Kasem Ali and PW12 Rohima Begum had not given a statement as recorded by me. It is not a fact that I did not investigate the case properly. He was re-examined thereafter on 24th May 2019, page 45.
Yes,
During the course of investigation, I visited, this is his examination in chief, Lordship. During the course of examination, I visited Lower Assam Hospital, Bongaigaon on 24/12/2016 at around 4:40 p.m. to see the victim woman and inquire about the matter. So the statement was recorded on 4:40 p.m. FIR was lodged on 4 p.m. I found Monwara Begum, alias Momota Khatun, on bed in the burn injury unit of the hospital. In presence of witnesses, Khatun Bibi, Bosiron Bibi, and Kamila Begum, I inquired Momota about the incident. She was in a position to talk and was in stable condition. She talked with me properly and inter alia told me that her husband is a drunkard, and after some days of the marriage, her husband Hafizul Rahman used to inflict mental and physical cruelty upon her, demanding dowry, and he demanded rupees 1,50,000 as dowry. That on 19/12/2016 at around 7 p.m., her husband and his friend Sofiur Rahman took alcohol in their rented house, and thereafter they again took alcohol in the nearby room of her brother-in-law Kasem, and she threw the glass containing alcohol, for which her husband assaulted her. That they had dinner together, and as it was late, Sofiur remained there in the same room. That around 1 a.m., her husband assaulted her with regard to his earlier dowry demand. That unable to bear the torture, she herself poured kerosene upon her. That she thought as to whether to die or not. That she thought that her husband will come forward to save her, but he did not come. That she changed her decision to die and went to her husband. That her husband told her that till now she has not died, and lighted the matchstick and thrown upon her. That initially the husband did not come forward to douse the fire, but subsequently he came forward. That on hearing her scream, Sofiur Rahman woke up from sleep, and he also tried to douse the fire. That her brother-in-law Kasem called 108 and took her to civil hospital. That on the next day of her husband and other family members brought her to Lower Assam Hospital and admitted her there. Exhibit 9 proved in original is the relevant portion containing the statement of the victim Monwara Begum, alias Momota Khatun, recorded by me under section 161 CRPC, which I recorded in the case diary. Exhibit 9(1) is my signature. When I meet her and talk to her, I found her in a stable frame of mind. And by talking to her, I never thought that she will die. Here also that question comes, Lordship, whether she was stable or not, that is that I will argue, Lordship. But if he is stable, whether she was under the impression that she is going to die and she needs to tell the truth, whether under that impression she was, because he says, when I meet her and talk to her, I found her in a stable frame of mind. And by talking to her, I never thought that she will die.
that is the impression of the IO.
There is no medical documents, therefore I'm that.
But the fact remains that she actually died.
Yes.
And this happened how many days after recording the statement?
2 days.
2 days.
2 days.
2 days.
So obviously the impression of the IO was not correct.
Lordship.
The damage done to her was far more than what the IO felt.
Lordship.
That is also a
No,
factor to be
here,
noted.
from the FIR, your lordship will find that which was lodged at 4 p.m. The informant says his sister is in critical condition.
Hmm.
Other witness also says that she was not able to speak.
No,
Within
that's all
40
right.
within
Mr.
40
Ahmed, you said that the conviction here is entirely based on the dying declaration,
declaration.
correct?
Ross.
According to you, the dying declaration was not recorded in compliance with the law
Law.
governing the subject.
Lordship.
So we will examine the matter from that perspective. But let us just browse to the evidence.
Lordship.
We are already on PW 13.
Lordship.
So another one to
One.
go, is it?
Lordship.
Let's finish it and then we'll go into that.
Lordship.
Yes.
I saw bandages over her face, hand, legs, stomach, chest, and other parts of the body. I also recorded the statement of witnesses who were present there at the time of recording the statement of Monwara Begum, alias Momota Khatun. Cross. I received the FIR on 24/12/2016 at about 4 p.m. at North Bongaigaon PP by GD entry number 614 dated 24/12/2016 at 4 p.m. The extract copy of the GD entry is not in the case diary, and it was received and registered at Bongaigaon PS at 9 p.m. The distance from North Bongaigaon PP to Bongaigaon PS is about 3 kilometers. The FIR was immediately sent at 4 p.m. to OC Bongaigaon PS. I was entrusted the in charge of investigation by the in charge North Bongaigaon PP in terms of GD entry. In the burn unit, nurses are available all the time. It is not a fact that the visitors are not allowed inside the burn unit. I have not recorded the statement of nurse on duty at that time. I have not recorded in the case diary the name of the nurse present there. The doctor was not present there. When I visited, I have not taken the permission of the doctor to inquire the victim. I took the permission from the nurse. I have not collected the mental and physical fitness certificate of the injured from the doctor before recording her statement as to whether the injured was fit to give the statement. I have not taken signature of the victim woman below her statement. It is not a fact that I have not recorded the statement as told by the victim. There is no comma, apostrophe, semicolon in the statement recorded by me. I have not recorded the statement of the doctor regarding the mental fitness of the victim to give the statement. I have recorded the statement of Sofiur Rahman and not as a witness. It is not a fact that I have recorded the statement of the victim on my own and not as told by the victim. It is not a fact that victim was not in a position to give the statement. In the FIR, it is mentioned that victim is taking treatment at Lower Assam Hospital in critical condition. It is not a fact that on 24/12/2016, I did not visit Lower Assam Hospital and recorded the statement of victim Momota Khatun and other witnesses in the hospital. So this is the evidence of Ayub.
Yeah, just a moment, Mr. House, just a moment.
Right. PW 14, he is the second investigating officer. He collected the postmortem report and submitted charge sheet. So his evidence I'm skipping for now.
Yes, his evidence is not very significant,
Not
is it?
significant, Lordship. Page 49 is CW1.
Yes.
Because his name came up in the evidence, therefore court examined him as court witness. I am acquainted with the accused and he is from my village. His wife Momota expired about 3 years back due to burn injury. The incident is of 2016. During the winter month, at the time, the accused was staying with his wife in a rented house at Bhaulaguri. Myself and the accused were working at BRPL plant at that time under contractors. On that day, at around 7:30 p.m., both of us left the BRPL plant in my motorcycle and came to his house. Momata's sister was staying with her husband Kasem Ali in the adjacent tenanted premises. Momata prepared food in her room. I, along with Hafizur, sat in the house of Kasem and saw TV in our house till 10 p.m. The landlord, name forgotten, also saw TV with us. Thereafter, I had dinner in the room of Hafizur. After dinner, I wanted to go to my house, but Hafizur and his wife told me to stay there as I was already late by that time. So I stayed there. We all slept in the same room. Hafizur and his wife slept on the bed. I slept on the bed prepared on the floor. There was a partition of curtain between us. At around 12 midnight, I wake up and from my sleep, hearing the screaming of Momata and Hafizur. They were shouting, "Bachao, bachao." I saw fire on the cloth of Momata, and Hafizur has put the blanket over her to douse the fire and succeeded in dousing the fire. I called Kasem and his wife and they came. I went to New Bongaigaon station with Kasem to bring a vehicle. Hafizur rang me up and told me not to bring the vehicle as the landlord has provided his vehicle. We returned, but before I reached there, Hafizur and Momata has already left for hospital along with Momata's sister. I came home to take money. I rang up Hafizur and he told me that Momata is stable and I need not come during the night. Next day morning, was released from civil hospital and admitted to Lower Assam hospital. I, along with my uncle Jahoruddin, went there. I talked to Momata. She was under bandage all over her body and head. I did not talk too much with her as doctor has restrained us. I asked her as to how she got fired, but doctor asked me not to disturb the patient. Momata's sister told me that Momata caught fire while heating water on the stove. Momata's sister was all along with Momata in the hospital from beginning. I inquired Hafizur as to how Momata got fire and he told me that Momata was heating water in the stove and caught fire. I was sleeping, so I did not notice when Momata went to boil water. After 3 days of Momata in Lower Assam hospital, her family members brought Hafizur to North Bongaigaon PP, and from there he was sent to custody on the next day. And on that day itself, Momata expired in the hospital. There was no quarrel between Hafizur and his wife Momata on that day, and we together had dinner on that night. We did not have any party on that day. Earlier also, I used to visit Hafizur's house and did not notice any dispute between Hafizur and his wife. Police inquired me about the incident. Cross. I tried to talk with Momata on the first day of her admission at Lower Assam hospital, and doctor prevented me from talking to her. Thereafter, I did not visit her. Initially, the expenses of treatment were met by accused. The brother of Momata insisted Hafizur to provide better treatment to Momata at Guwahati. Momata's brother, along with some Amsu, brought Hafizur to the outpost and insisted Hafizur to call his guardian. I gave rupees 2,000 to Hafizur and he brought some money from Borpeta. During that time, there was scarcity of cash transaction due to demonetization. So this is the evidence, Lordship, used by the prosecution side. And thereafter, he was examined as under section 313 CRPC, page 51.
But there is a marked contradiction
Lordship,
between the evidence of CW1
Lordship.
and the statement of the accused recorded under section 313 CRPC,
Lordship.
particularly with regard to question number 10.
Yes.
What do you have to say on that? He has given a completely different version.
Regarding this, Lordship will. kindly say-
You would also rely upon the evidence of CW1,
Lordship.
but which of the two is correct?
No, from the evidence of CW1, your Lordship will find that he said he was sleeping, and after hearing the scream, he woke up. And prior to that, there was no quarrel. On that aspect, Lordship,
Please come back to CW once again.
Lordship.
CW1.
Page 49.
So here he doesn't say anything that the accused had gone to somebody else's
No,
house.
that part is silent.
And it was 12 at midnight.
Midnight, when he heard the scream of both,
Hmm.
then he woke up.
So something is amiss
Yes,
here.
it is there.
That
But
you agree?
That I agree, Lordship.
Okay.
I'm only on one point, Lordship, that prior to that, he did not heard any hue and cry. That part, Lordship.
Looks like the accused was not speaking the truth. But you proceed, we'll see. We'll see the totality of the.
Lordship. In question number 21 also he said,
Yes.
Mamata sustained, page 58. Do you have anything else to say? Mamata sustained burn injuries from stove. In hospital, she told me so. She lighted the stove to warm the water. It was winter month. At that time, I was viewing TV in her sister's house. Our room were nearby, some same landlord. And those sister and sister's husband, cousin sister's husband, they were declared hostile. They have not supported the prosecution case. Lordship.
All right.
And thereafter, as the exhibit 9 was exhibited subsequently, so he was again examined as under section 313, that your Lordship will find page 59. Page 59, question number 8, page 59A.
Yes.
Do you have anything else? So she was not in a position to talk, and as such, she could not give that statement. Initially, I made the expense of her treatment, but I ran out of money and could not bear her expenses. And for this, her brother Gudu Ali lost the case against me. The deposition of the police officer that he recorded the statement of my wife is not correct, as she was not in a position to speak. And the exhibit 9, your Lordship will find 118A page.
188.
18, 118, Lordship.
All right. What is this?
This is the 161 statement of the victim.
Yes.
At page 118A, your Lordship will find that 420, he proceeded towards hospital. 430, he reached there, and 440, he examined the victim.
Let us read it once.
Lordship.
Yes.
4:20 p.m. Departure. Now I, along with staff, have proceeded to the Lower Assam Hospital for investigation of the case. 4:30 p.m. Lower Assam Hospital arrival. Now I, along with staff, have arrived at Lower Assam Hospital. Note: after arriving at Lower Assam Hospital, I have found injured Mamata Khatun in the burn unit of the hospital in injured condition, and I endeavor to question her in connection with the case. 440, questioning the injured person. Now, in connection with the case, I question the below named injured person in presence of the witnesses, namely Khatun Bibi, Bosiron Bibi, and Komela Begum, and recorded her statement as follows. Statement, Lordship. My name and address are as mentioned above. I am aged about 23. I am a housewife. In connection with the incident, I went to state that accused Hafizur Rahman is my husband. I got married to him about 5 months back. My name is Monwara Begum, but the members of my family call me Momota.
Oh. This is a dying declaration.
Lord.
The author should write a novel.
It's a 161 statement, but I think there are decisions saying that it is allowed. 161 statements, because police has no ill will towards that person who is going to die. So they accept 161
No,
statement.
but you think a person who is about to die in 2 days' time will go into all these details? What is her nickname? Who calls her what? Does it not sound a little too perfect to be true? Anyway, just posing a
Yes,
question.
yes, yeah, everything depends on facts.
Yes.
But she was in a position to speak, so
All right. Yes.
My husband, Hafizur Rahman, is a drunkard. Since after some days of our marriage, my husband had been torturing me both physically and mentally, demanding dowry. He demanded rupees 1,50,000 as dowry. We stay in the rented house of Joinuddin at Bhaulaguri. Around 7 p.m. on 19/12/2016, my husband and his friend Sofiur Rahman consumed liquor in our rented house. Our brother-in-law, husband of younger sister, Kasem, stays near our rented house. They visited Kasem's house and started consuming liquor there too. I threw away the liquor which was kept in the glass. Then my husband assaulted me. Later, we all three had our dinner. Sofiur wanted to return home, but since it was night, we did not let him go. My husband and I slept on the bed, and Sofiur slept on the pakka floor of the same room by covering himself with a blanket. Sofiur fell asleep. Around 1 a.m., my husband assaulted me, telling about the dowry which he had demanded previously. Being unable to endure the torture meted out by my husband, I poured kerosene on my person. After pouring the kerosene, I thought for some time there whether I should die or not. I thought if I pour kerosene, my husband would come to pacify me, but he did not. After thinking for a while, I decided to leave and come close to my husband again. Then telling me, "You'd have not died yet," my husband, with an intention of killing me, light a matchstick and set fire to me. I tried to extinguish the fire. At first, my husband did not come forward to extinguish the fire, but he came forward after a long time. Hearing my scream, Sofiur Rahman woke up and tried to extinguish the fire. Sofiur Rahman is innocent. Later, my brother-in-law, Kasem called 108 ambulance. My husband and my younger sister Rohima Begum took me to Bongaigaon Civil Hospital for treatment that day itself. On the following day, that is on 20/12/2016, my husband and the members of my family took me to the Lower Assam Hospital and got me admitted there. Now I am undergoing treatment in Lower Assam Hospital. Since I was set ablaze, I sustained burns in my mouth, hand, leg, stomach, chest, and different parts of my body. My husband works as a contractor in BRPL. He has sufficient money, but he has not spent any amount of money for my treatment. The members of my family are very poor. They do not have sufficient money. Due to the shortage of money, my bandage could not be changed from yesterday. My husband has not paid any attention to my treatment. He set fire to me with an intention of killing me. I have to say this much only.
So what is wrong with this dying declaration?
This dying declaration, Lordship, first of all, I will say that the FIR which was lodged on 24/12/2016.
Yes,
And incident is of 19/12/2016. During these 5 days, she did not disclose about her this incident to anyone, not to doctors, not to other relatives, not to anyone. Even that is on record that they repeatedly asked her, she did not disclose. But only after lodging of this case and after arrest of her husband, this she disclosed this incident. And
there is a delay of about 5 days.
Lordship.
Okay.
And then your Lordship will find
Is there any explanation for the delay?
no explanation is there.
No explanation. No explanation.
I was busy in the treatment, she said in the FIR.
1 minute.
Lordship.
I was busy.
Yes.
And from the record, your Lordship has already seen that from the evidence, it is clear that appellant took the victim to the hospital. He admitted her, he doused the fire. It is admitted by the witnesses also.
So even if the statement of the victim is taken on the face value,
Lordship.
then she says that she's the one who had poured kerosene oil on her.
Lordship.
And the intention was to set her on fire. But midway, she changed her mind. And that is the time when the husband came and lit the matchstick.
Lordship.
So if this version is accepted on the face value,
Lordship.
then what do you say? The conviction would not be sustainable?
Under section 302, it will not be sustained.
Why is that?
Because Lordship, the immediate prior intention was not there. Otherwise, he would have poured kerosene and lit the matchstick.
Mhm.
Subsequently, also, he doused the fire. It is not that he left her in her condition, Lordship. He doused the fire, he took her to the hospital. He took,
No, but when he actually lit the fire, then he had the intention. The
That-
intention can generate any time, at any point of time.
that knowledge may be there, that if I light fire, she may die.
Hmm.
But intention probably is not there from the circumstance what it appears to be. Because he did.
You mean to say the premeditation is not?
Premeditation is not there.
All right.
And Lordship, the dying declaration which is recorded by the IO, they did not contain the endorsement of the doctor, whether she is fit to give the statement or not. And apart from that, there was the relatives were present in with the deceased when the statement was recorded. And in this regard, just I am relying on a judgment of Honorable Apex Court, Lordship. 2016-14 SCC.
Mr. Mahajan, you are waiting for which case?
2 and 3.
Okay, today there is a single bench and then the court has to rise at 1:15. Looks doubtful. You can ask your junior to give a date. We can have it after a couple of weeks. Yeah. Yes.
Uh, 2016-14 SCC, Lordship. And paragraph 15 and 17 underline.
Paragraphs?
15 and 17. May I read?
Yes.
Paragraph 15. The courts below have to be extremely careful when they deal with a dying declaration, as the maker thereof is not available for the cross-examination, which poses a great difficulty to the accused person. A mechanical approach in relying upon a dying declaration just because it is there is extremely dangerous. The court has to examine a dying declaration scrupulously with a microscopic eye to find out whether the dying declaration is voluntary, truthful, made in a conscious state of mind, and whether without being influenced by the relatives present or by the investigating agency who may be interested in the success of investigation, or by the or which may be negligent while recording the dying declaration. Paragraph 17, Lordship. A number of times, the relatives influence the investigating agency and bring about a dying declaration. The dying declarations recorded by the investigating agencies have to be very scrupulously examined, and the court must remain alive to all the attendant circumstances at the time when the dying declaration come into being. In case of more than one dying declaration, the instruction contradiction in those dying declaration are extremely important. It cannot be that a dying declaration which supports the prosecution case alone be accepted. So this part is not relevant. Hmm. 2010 to 10 to 2010 to assessment. Lordship, just something missing here, one judgment that I am relying on 2010 to SCC. I will give a copy, Lordship, of this. 2010 to SCC, page 85, para 24, 25, 26. Here the court says that Honorable Apex Court said that the dying declaration, which relied on by the prosecution, should inspire full confidence of the court, Lordship. If there is any doubt, Lordship, that benefit would go to the accused side.
So what is the doubt here? What is the doubt creating factor? Just because relatives were present, that by itself cannot be a doubt creating factor.
No, first of all, Lordship, as I have pointed out that during 5 days, she did not complain that her husband has tortured her or husband tried to kill her. There was no complaint regarding this, Lordship. Even in the FIR also, that allegation is not there. From the FIR, just I'm again taking your Lordship to the FIR. She did not disclose that those things. Therefore, 2 persons were made accused. Allegation against 2 persons that they poured kerosene oil, they set her on fire. But in dying declaration, what comes, Lordship? She poured kerosene on herself, husband set fire. So till lodging of the case, she did not disclose anything to anyone. When the husband was not there, he was handed over to police. Subsequently, this dying declaration came into existence.
So, but her statement was not recorded earlier.
No, not recorded.
Then the first time statement recorded, and that's where she says that.
That part, Lordship, my submission is that she did not, her statement was not recorded, and even she did not disclose anything to anyone. Therefore,
No, that's what we are asking, Mr.
Yes,
Ahmed,
Lordship.
just to understand the nitty-gritties.
Lordship,
The FIR was lodged on 24th of December.
Lordship.
Before that, the police was not aware of the incident. Correct.
Lordship. But there has to be one GD entry because this is
Where is the GD entry?
that is not exhibited by the prosecution side.
But is there a GD? Ms.
if
Jahan,
there-
you please take note when you argue.
If there is
No, answer
Lordship,
this.
this kind of incident happens when it is admitted in hospital, There has to be a GD entry, Lordship.
There is no GD entry
No
here.
GD entry. There is nothing that sort of.
No, there was a, on 1912, at 2 AM at night. No, there was a GD entry on receipt of the FIR, the GD
Right.
entry was made.
On receipt of the Azahar, one GD entry is made.
FIR was lodged on 24th of December.
24th of December.
Hmm.
I'll check from the records.
One GD entry is exhibited that your Lordship will find page 110.
That was what?
That is dated 24/12/2016, after lodging of the Azahar.
After lodging.
Yes.
1110. At 4 PM. Lordship will find receipt of Azahar and forwarding the for registration of case. This is the GD.
It started with 24th of December only. Nothing before that.
Yes.
And second thing, Lordship will find that in the FIR it is said that she is in critical condition and FIR was lodged on 4 PM, at 4 PM. And statement was recorded 4:40 PM on the same day, after 40 minutes. So the IO said she was stable.
No,
So
what
there
the
was-
IO said that it didn't occur to him that she could die. But that is of no moment here because she actually died after 2 days.
Yes, but
So IO's assessment of her health condition, what relevance does it have?
no, my submission to your Lordship is that regarding her health condition and mental fitness, there is contradictory evidence on record. FIR says she was in critical condition. As per IO, she was stable, and there is no medical report on record that on when her statement was recorded, she was stable and fit to give her the statement. The doctor was
Let
not.
let us see, did you cross-examine the IO
Yes,
on
yes,
this point?
yes.
Let us revisit. Let us revisit what actually was asked.
Page 43, your Lordship will find
Hmm.
first cross-examination. Page 43.
Yes.
As per the FIR, the date of occurrence is 19/12/2016 at 2 AM. And the FIR was lodged on 24/12/2016. North Bongaigaon is about 4 kilometers away from the place of occurrence. I recorded the statement of the injured on 24/12/2016 at Lower Assam Hospital, but I did not obtain her signature in the statement. I also did not obtain signature of Khatun Bibi, Bosiron Bibi, and Komela Bibi, in whose presence the statement was recorded. The injured was in burn unit of the hospital. Before recording the statement of injured, I did not obtain medical certificate from doctor as to whether she was mentally fit to give statement. In the statement of the injured, I also did not mention that as per her wish and her version, I recorded the statement because the statement has to be voluntary. Those things were not ascertained by him. Whether she was tutored by family members or not, those things he have to ascertain. In the statement of the injured, I also did not mention that as per her wish and her version, I recorded the statement. I seized no any burn material. The house of the informant is at Chinese Market, Bongaigaon, and the place of occurrence is about Bholaguri. I have not collected any medical document of the injured from Bongaigaon Civil Hospital as well as Lower Assam Hospital, where the injured was taken after the incident and was provided treatment. It is not a fact that injured was not in a position to speak, and she did not give any statement before me. I did not take steps to record the statement of the injured by doctor. In the FIR, it is not mentioned who wrote the same. So this contradiction I am skipping. Your Lordship may kindly now turn to page 46, his second cross-examination. Page 46. I received the FIR on 24/12/2016 at 4 p.m. at North Bongaigaon, PP GD entry number 614, 24/12/2016 at 4 p.m. The extract copy of the GD is not in the case diary and it was received and registered at Bongaigaon PS at 9 p.m. The distance from North Bongaigaon PP to Bongaigaon PS is about 3 kilometers. The FIR was immediately sent at 4 p.m. to OC Bongaigaon PS. I was entrusted the charge of investigation by the in-charge North Bongaigaon PP in terms of GD entry. In the burn unit, nurses are available all the time. It is not a fact that the visitors are not allowed inside the burn unit. I have not recorded the statement of nurse on duty at that time. I have not recorded in the case diary the name of the nurse present there. Doctor was not present there when I visited. I have not taken the permission of the doctor to inquire the victim. I took the permission from the nurse. I have not collected the mental and physical fitness certificate of the injured from the doctor before recording her statement as to whether the injured was fit to give statement. I have not taken signature of the victim woman below her statement. It is not a fact that I have not recorded the statement as told by the victim. There is no comma, apostrophe, semicolon in the statement recorded by me. I have not recorded the statement of the doctor regarding the mental fitness of the victim to give her statement. I have recorded the statement. So this is regarding. It is not a fact that the victim was not in a position to give the statement. In the FIR, it is mentioned that victim is taking treatment at Lower Assam Hospital in critical condition.
All right, so
These things were brought to his notice, Lordship.
so please sum up your argument.
Lordship. And regarding presence of relatives, which I have submitted before Lordship, because I am relying on a judgment of Honorable Apex Court. 2007 9 SCC 151, Lordship. Paragraph 9 and 10, Lordship. May I read?
Yes.
This is a case where the conviction of the where the basis of conviction of the accused is the dying declaration. The situation in this in which a person is on his deathbed being exceedingly solemn, stern, and grave is the reason in law to accept the veracity of his statement. It is for this reason that the requirements of oath and cross-examination are dispensed with. Besides, should be dying declaration be excluded, it will result in miscarriage of justice because the victim being generally the only eyewitness in a serious crime. The exclusion of the statement would leave the court without a scrap of evidence. Though a dying declaration is entitled to great weight, it is worthwhile to note that the accused has no power of cross-examination. Such a power is essential to elicit the truth as an obligation of oath would be. This is the reason the court also insists that dying declaration should be of such nature as to inspire full confidence of the court in its correctness. The court has to be on guard that the statement of the witness deceased was not a result of either tutoring or prompting or a produce of imagination. The court must be further satisfied that deceased was in a fit state of mind after a clear opportunity to observe and identify the assailant. Once the court is satisfied that the declarant was true and voluntary, undoubtedly it can base its conviction without any further corroboration. It cannot be laid down as an absolute rule that the dying declaration cannot form the sole basis of conviction unless it is corroborated. The rule requiring corroboration is merely a rule of prudence. This court has laid down in several judgments the principle governing the dying declaration, which could be summed up as indicated in Paniven. There is neither rule of law nor of prudence that dying declaration cannot be acted upon without corroboration. If the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. This court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased has the opportunity of observe and identify the assailant as and was in a fit state to make the declaration. Where the dying declaration is suspicious, it should not be acted upon without corroborative evidence. Where the deceased was unconscious and could not make any dying declaration, the evidence with regard to it is to be rejected. A dying declaration which suffers from infirmity cannot be basis of conviction. Merely because a dying declaration does not contain details as to occurrence is not to be prejudiced. And paragraph 11, your lordship will kindly see now. In the instant case, it is to be noted that the evidence of PW3 and the doctor clearly shows that before the dying declaration was recorded, the relatives of the deceased, including PW7 and 8, were present with her and were subsequently asked to leave the room where the dying declaration was recorded. Though much was made of the dowry demand by the courts below, there is only a vague reference to it in the dying declaration. The statements of PW7 and 8 that they had told the investigating officer about the dowry demand is not correct. They had not said so before the investigating officer. It is also significant that prior to the death, neither the deceased nor her parents had complained to the police or told anyone else about any alleged dowry demand. In the circumstances, the dying declaration itself was clearly the result of tutoring and was not a free and voluntary one. The courts below were therefore not justified in placing reliance on the same. Additionally, there was only a vague reference of dowry demand to the police, which in any event has not been established and also was not told during investigation.
Yes. Yes.
Yes, now, lordship, 1975, 3 SCC 219, Balakram.
So, Ms. Jahan, we cannot conclude today. We'll fix it again on Tuesday.
Lordship.
You,
I have few judgments also that
you
needs.
take note of the
Hmm.
arguments he has made, and
No,
decide.
I've already.
We'll rise at 12:15, and then we have a single bench,
Hmm.
and the court has to also
I'll reply it on
finally
Tuesday.
finish the day's work at 1:15 today because of some administrative reasons.
Then I'll reply it on Tuesday.
Yes.
This 1975 3 SCC lordship, Balakram, paragraph 53 and 56.
What is the point?
Here that regarding recording of dying declaration by investigating officer and regarding presence of the relatives when dying declaration was recorded. Two things. Paragraph 53, I am reading, lordship. The second dying declaration. The second dying declaration is alleged to have been made to the investigating officer. Investigating officers are keenly interested in the fruition of their efforts, and though we do not suggest that any assumption can be made against their veracity, it is not prudent to base the conviction on the base on a dying declaration made to a investigating officer. And then your lordship may skip paragraph 56. Paragraph 56. Quite apart from this consideration, the dying declaration can have hardly any evidentiary value because Triveni Sahai was in the Triveni Sahai is the deceased here. Triveni Sahai was in the midst of friends and admirers right since the time of the incident until dying declaration was recorded. Dharmpal was in his constant company, and it is not unlikely that names of political opponents like Balak Ram, Dr. Kohli, and Beni Khan were freely bandied about. The dying declaration could then be naturally influenced by the opinion and inferences of close relatives like Dharmpal.
All right, so Mr. Ahmed,
I will place two more judgment also before your lordship. In the next day, your lordship judgment is also there regarding fitness, and I will conclude on that day.
then we'll have it on Tuesday next part of matter. Likho, heard Mr. A. Ahmed, learned counsel appearing for the appellate. Ms. S. Jahan, learned APT Assam is present on behalf of the states. Arguments remain inconclusive. Registry to therefore, this is again on 15/11/2022 for further hearing as a fixed part-heard matter.
Obliged.
Number 2 and 3, Maluk. Item number 2 and 3, Maluk. Can we take it up next week, Maluk?
2 and 3 next
2
week.
and 3, my learned senior is there, Maluk. 2, Lordship has heard the matter before as well, Maluk. Next,
So we'll have it on next Thursday, 17th. 2 and 3, 17th.
Maluk.
Your Lordship, item number 4, too, please kindly fix the date. Your Lordship.
Item number 4,
4.
of which division bench?
Yes.
Yes. When do you want it?
As early as any day, Your Lordship, next day,
17.
7.
should face actions, my lord. But so far as this is concerned, this is totally illegal or my lord, some sort land-based sought to be taken away on the ground of my lord relinquishment, my lord, without any deed or anything like that, my lord. Therefore, your lordship wanted to dispose of the matter. At that stage, they made a prayer that they wanted to explore some possibility of compromise. 2 months they've done nothing, my lord. Not even approached, my lord. Now again a further prayer is being made, my lord. The rest I leave it to your lordship, my lord. Whatever your lordship.
2 weeks time may be given, Lord. Otherwise, my lord, the photographs are very clear. Lordship has seen some constructions have been done there. My lord, if something can be done, it can be sorted out. my lord.
You will grant you 2 weeks, but
No.
on the next day you will furnish proof of steps taken
Lordship.
since the order dated 8/9/2022
Lordship.
for arriving at a amicable settlement of the dispute. You furnish proof, bring it on record.
Lordship.
We'll list it after 3 weeks.
If
Let us see, let us see if we can finish
it
it.
is absolutely up to the authority, Lord, I can just apprise them that if can be done, you do it.
No, but are you
Lordship.
seeking time on behalf of the authority
Yes,
or on
yes,
your
yes.
own behalf?
Yes, my lord. On behalf of the authority.
Huh?
On behalf of the authority, my lord.
Because the submission was not initially made on basis of the authorities' my lord instruction. It
Yes,
was
yes.
made on behalf of the councils. my
No,
lord.
during deliberation,
Now, Lord.
during deliberation before the court only, it was.
Heard Mr. M. Dattalan, counsel appearing for the petitioners. Also heard Mr. D. Nath Lanet, senior government advocate Assam appearing for the state. Full stop. Mr. A. Deka, Lanet counsel is present on behalf of the private respondent. Full stop. Today, when these petitions were called up for admission hearing, Mr. Nath submits that 2 weeks further time be granted for exploring the possibilities of a amicable settlement of the dispute involved in these proceedings. Full stop. Responding to the same, Mr. Datta submits that since the order dated 8/9/2022 passed by this court, granting time to the departmental authorities to explore the possibilities of an amicable resolution of the dispute. No action, whatsoever, has been taken in the matter, and therefore granting of further time on the request of the learned government council would be a futile exercise. Full stop. Be that as it may, since a projection has been made that there is a possibility of an amicable settlement of the dispute, and considering the request made by Mr. D. Nath, admission hearing of these cases are adjourned till 12th of December 2022. Full stop. On the next date fixed, the learned government advocate to appraise this court as to solution, if any, that has been arrived at in the matter. Full stop. Mr. Nath to also produce evidence to show that the authorities have in fact made an attempt for amicable settlement of the disputes involved in this batch of writ petitions. Let these matters be listed accordingly.
Diploma.
May I please your lordship. No, I am appearing on behalf of Mr. S.K. Das, my lord. He is on legs in court number 4, my lord. However, we have submitted our affidavit in opposition, my lord, on the last occasion.
Who is for the petitioner? Petitioner's counsel.
Mr. K. Kolita. As per the online case status.
K. Kalita.
Yes, my lord. I printed out a page of the case status. my lord.
None is appeared for the raised petitioner on call. The learned standing council Guwahati High Court is present and submits that affidavit on behalf of the respondent number,
The respondent numbers 1, 2, and 3.
on behalf of the respondent numbers 1, 2, and 3 has already been filed by serving advance copy upon the petitioner's counsel. Full stop. Be that as it may, since the petitioner's counsel is not present before the court today, this matter stands adjourned for 3 weeks.
I am obliged, lordship.
Yes,
Review petition, lordship.
who is for the other side?
Your Lordship, I'm appearing for Senior Advocate Dilip Mazumdar. He's on legs in court number 12. I pray that date may be fixed.
Lordship, on any date, lordship, Monday or Tuesday,
No, Monday, Tuesday, after 2 weeks.
lordship.
Mr. D. Kalita, learned counsel for the review petitioner is present. A prayer for adjournment has been made on behalf of the respondents on the ground that the learned senior counsel engaged in this matter is not available for arguing this case today. First up, considering the ground on which the prayer is made and in view of the fact that the petitioner's counsel does not have any objection to the said prayer, this matter stands adjourned for 2 weeks.
Obliged, Your Lordship.
May I please, your lordship, my lord? We want to withdraw this petition, my lord. Liberty may be given, my lord. There is some typographical error, my lord.
Liberty, why? Review petition, why liberty? Review petition, if you withdraw, no liberty. What is the problem?
But there is some error in the petition, my lord. But
Can be after 10 weeks, my lord, my senior will come.
No. You can't ask the court to wait for your senior. I'm dismissing it right now.
Liberty may be given, my lord, sir.
Mhm.
I'm not pressing this, review reason, my lord. I've already informed the other side, my lord.
May I please your lordship? My lord, there are some mistakes in the petition in 2-3 places, my lord.
What is the mistake?
Mr. My lord, there's a direction of your lordship's president and secretary of that particular Namgor, my lord. In the petition, my lord, that has been not been typed out, my lord. There's a mistake. And also there is one statement also I found that is not correct, my lord. So just give a liberty, I'll file a fresh on my lord. I don't want that should remain, my lord. That mistake should remain.
Yeah, who's there for
I
the
told
government?
Mr. Sekia. He said,
Where is he?
he has given it, he met my colleague, my lord. He said, I told him that we are going to do it. He told
Mr.
me,
M. Nath, Leonard Senior Counsel, it's stated by Mr. But there are some is that there are some defects in constitution of the review petition, and therefore he be permitted to withdraw this review petition with liberty to file afresh after rectifying the defect. Since the review petition has been listed for the first time before this court today, and in view of the fact that the respondents' counsel do not have any objection if the prayer is allowed, the review petition stands disposed on the request of Mr. M. Nath, Leonard Senior Counsel. This review petition stands disposed of on withdrawal with liberty as prayed for.
God bless, my lord.
What is this matter?
Lordship has already heard it, but it is that matter, my lord, in the district of Lakhimpur, my lord. A plot of land allotted, my lord, and settled with some Samuju Sangha. That is, my lord, illegally occupied by the writ petitioner, some portion of the land. Now, where, my lord, the steps have been taken for their vacation, they have moved this honorable court by way of this writ petition.
Why
Well,
is it before this court?
My lord,
Why this matter is before this court?
because my lord, on earlier occasion, lordship was taking a bench for matter, then my lordship has heard it in part. Lordship has already made an indication to the other side, my lord, that no prima facie case has been made out in the instant writ petition. In fact, they are enclosures. Lordship has framed my lord's mind on the last occasion. And my lord, lordship has also put a question to the Planet Council appearing for the petitioners on the last occasion as to how much time
Who
they
is the
require.
counselor for petitioner?
My lord, earlier, my lord, P. Pallab Kotoki appeared, my lord, now there is a change of council. They are now led by senior counsel, my lord, C.C. Doctor. On the last occasion, my lord, they took time. My lord, on the ground that the senior
but,
counsel has been newly engaged.
Is the name of Mr. Datta shown in the cause list?
My lord, we'll have to check. Yeah, for this one, it's like-
Do you have the junior of Mr. Datta?
I think nine, it would have been said this. His name is not reflected in the cause list. Yeah, say it.
Then the matter cannot be closed today because his name is not shown in the cause list. Let it be listed again.
No, my lord, no difficulty.
Why should it be parted before this court? The bench, single bench will
No, my
not.
lord has already had it because My lord has already heard it, my lord. It was, my lord, with a consensus of all the parties, my lord. Lordship has agreed, my lord, to keep it part.
Achha, all right, you should take down. None has appeared for the writ petitioner when the matter is called up. Mr. R. Barpujari, learned counsel representing the respond numbers.
My
You
lord,
are appearing,
respondent-
Mr. Representing Mr. Respond numbers 1, 2, and 3 is present. Mr. P. S. Dekal and his senior counsel assisted by Ms. N. Chakraborty is also present on behalf of the respond number 4. However, since the petitioner's counsel is absent, this matter cannot be heard today. It appears that the name of the newly engaged counsel for the writ petitioner, namely Mr. S. Datta, has not been shown in the cause list. As such, registry to list this matter again after 2 weeks by reflecting the name of Mr. S. Datta and a counsel for the petitioner in the cause list. That day we'll finish it off.
Yes, in fact, on the earlier occasion also, lordship has made up a mind, my lord.
But their names.
No,
are
no, no,
not
no,
shown.
no difficulty. No difficulty. Time obliged, my lord.
May it please your lordship.
What is this matter?
My lord, that their registration underneath was rejected, my lord. And they have approached this court for granting the registration for for the subsidy scheme.
Subsidy scheme.
Subsidy scheme for registration. Earlier, they have to register themselves, and before that, Aadhaar card and everything they may register.
This matter was
Salient
earlier
points,
heard.
salient points are given, my lord.
Yes, but
Yes, today, I think,
today-
well, also as per your convenient, one, that can be fixed.
why don't you agree on a date sometime in the middle of December? And we'll finish it off, or first week of December. Because now the single bench may not be sitting regularly. Let us have it on 8th of December. 8th of December. I heard Ms. N. Shekhar, Learned Counsel appearing for the writ petitioner, also heard Mr. A. Kalita, Learned Standing Counsel Industries and Commerce Department. Assam appearing for the respond numbers 1 and 4. And Mr. B. Chakraborty, Learned CGC appearing for the respond numbers 2 and 3. As prayed for by Learned Counsel for both the sides. Let this matter be listed again on 8/12/2022 as a fixed part of matter.
Obliged.